Hi, it's Nate Charles, and welcome back to another episode of the Rule of Law Brief. A couple days ago, I said, hey, we love questions. Send us your questions. We're doing this because we want to educate the public about the things that are on your mind when it comes to national security, foreign policy, and the law. And we do. We love your questions. Keep them coming. We get a lot of great video ideas from your questions. It is also the case, however, that we occasionally get our video ideas from idiotic comments by people on the internet, and this video falls into that category. Today, we're going to talk about a misunderstanding that the Republicans are currently exploiting in order to justify these illegal strikes on the drug boats in the Caribbean. In particular, I've seen Senator Tom Cotton exploit this misunderstanding egregiously, and he's clearly doing it in bad faith. So the misunderstanding I'm getting at is whether the president gains the authority to use military force simply by declaring a group a foreign terrorist organization under the Immigration and Nationality Act. And the short answer is absolutely not. No way in hell, no. In fact, pretending otherwise is one of the ways that the president and the Republicans are currently trying to justify their use of extra-legal force by the military against these drug cartels. All right, so what does the law actually say? Under the Immigration and Nationality Act, the Secretary of State, acting as the president's delegated authority, can designate a foreign group as a foreign terrorist organization, or an FTO. To do that, the group must meet three criteria. One, it must be foreign. We'll talk about why you can't do it to domestic groups in another video. Two, it must be engaged in terrorist activity or terrorism. And there are some very long, very arcane definitions for terrorism and terrorist activity within the statute itself. And three, its actions must threaten the security of U.S. nationals or the national security of the United States, which means that its national defense, its foreign relations, or its economic interests. Now, again, this is codified in the Immigration and Nationality Act because it's ultimately an immigration law criteria. They sit inside a statutory framework designed to regulate people's entry into the United States or their removal in cases of deportation. This has nothing to do with kinetic operations overseas. It has nothing to do with military counterterrorism at all. And I've got quite a bit of experience with this because I've conducted those counterterrorism operations within the U.S. military. I've also dealt with the immigration implications of these policies in my role as an immigration attorney specializing in high-risk asylum cases. So once the FTO designation is made, there are a few consequences. A few material things that the president is allowed to do under this legal framework. They're all serious, but they're not military. One, material support to that FTO becomes a federal felony. My colleagues in the counterterrorism section of the U.S. Department of Justice used to prosecute these kinds of cases, and they did some really excellent work in that regard. But again, it's not about the use of military force. Two, members and affiliates become inadmissible to the United States, and they can be removed under federal immigration law after a hearing in front of an immigration judge. And three, financial institutions must freeze the assets that are held by that organization. And at this point, I have to add a little sort of footnote to this video. There's something called a specially designated global terrorist. That's a designation that the Treasury Department can make under the International Emergency Economic Powers Act. It's effectively a form of an international economic sanction. That's an entirely different regulatory framework, and I'm not going to get into it right now. But for purposes of this video, you should know that that does not authorize the president to conduct military operations either. Now, again, an FTO designation comes with powerful legal and financial instruments, but it doesn't create a license for war. Nothing in the Immigration and Nationality Act authorizes the president to deploy troops, conduct lethal operations, or initiate hostilities simply because a group is on the FTO list. Okay, so what does authorize the president to conduct military operations against a terrorist group? I mean, after all, we did fight Al-Qaeda for decades. If you want to use military force, you need something entirely different. You need an authorization for the use of military force under the War Powers Act. An AUMF is issued by Congress, not the president. It is the domestic law mechanism that allows the executive branch to employ military personnel overseas. The central authority here, the one that allowed the presidents to conduct counterterrorism operations overseas after 9/11 for the last 25 years, was the 2001 AUMF. That AUMF specifically allowed military force against, and I quote, those nations, organizations, or persons that planned, authorized, committed, or aided the attacks of September 11th or harbored the perpetrators. That's it. Those are the only people that we were allowed to target under the 2001 AUMF. That was essentially Al-Qaeda and its affiliates. Any counterterrorism operations that you saw conducted throughout the world since 2001 were conducted under that congressional authority. And critically here, that authority does not apply to drug cartels at all. In 2001, Congress did not hand the president a blank check. Congress tied those authorizations directly to one historical event and the actors who are responsible for it. Period. Again, every major counterterrorism operation since 2001 against Al Qaeda, the Taliban, AQAP, ISIS, and various splinter groups has relied on the 2001 AOMF. And that was legal, but it did not depend on the Immigration and Nationality Act. It did not depend on any kind of a foreign terrorist organization designation by the U.S. State Department. It did not apply to economic sanctions applied to groups who had specially designated global terrorism status. And it certainly did not justify unilateral presidential directives to commit offensive military operations, which are clearly in violation of Article 2 of the U.S. Constitution. If a terrorist group lacks a meaningful lineage to Al Qaeda or the Taliban, the 2001 AOMF becomes exceptionally weak in terms of a domestic law foundation. Without a new specific authorization from Congress, the president is limited to narrow Article 2 self-defense authorities, time-bound, constrained, and subject to oversight, particularly the types of oversight that are laid out in the War Powers Act. Blurring the line between these FTO designations and authorizing war is incredibly dangerous. It's also patently illegal. It collapses Congress's constitutional role and creates the illusion that the executive can escalate conflicts simply by labeling adversaries as terrorists. We have a structured legal architecture for counterterrorism. It's imperfect, but it exists for a reason. The distinction between immigration and sanctions regulation and military force authorization is not optional. It is foundational. It is fundamental to the concept of due process under the U.S. Constitution. If military action is warranted, the solution is straightforward. Congress must pass a new AOMF. It is not okay for President Trump to use shortcuts against these drug cartels. It is not okay for President Trump to rebrand an immigration tool, and it is not okay for Donald Trump to issue unlawful authorizations for the use of military force.